Welcome and thank you so much for joining us for our webinar today. We appreciate you taking the time with all that's going on to join us and learn how to protect your young or growing family. We are the Koppenbarger & Koppenbarger law firm, and we have been in business for over 40 years. We have 9 attorneys and dozens of support staff that are highly qualified and happy to serve you at any time. We have offices all over the state of California and are able to meet with you in person or through virtual means such as this. My name is Amanda Carroll, and I am the Client Services Assistant for the Koppenbarger & Koppenbarger law firm. We have helped so many people in their time of need, and we pride ourselves on working as a team, not only within the firm, but also with our financial advisors, CPAs, and other professionals that are instrumental to creating the best plan for you and your family. Your presenters today are Chris Carroll and Victoria Horvatich. Victoria is one of the 9 attorneys within our firm, and she works in both estate planning and estate administration. She works mainly in our San Jose, Sacramento, and Santa Cruz areas, but using technology, she can meet with anyone, anywhere. Victoria received her bachelor's degree from University of Pacific and her law degree from Santa Clara University. She has worked within the legal industry for 5 years, 3 of which have been focused on estate planning. Victoria lives in Santa Clara with her fiance, Zach, and their 2 kittens. She actively participates in her community by volunteering with a youth group at her church and supporting local charities. Chris is our firm's CEO, and he has been in the financial and legal industry for almost 15 years, with Koppenbarger & Koppenbarger for the last 9. Chris received his bachelor's degree in business management and marketing from San Jose State University and recently received a certification in executive leadership from the Graduate School and Business at Stanford University. Chris, his wife, and their 3-year-old daughter live in San Jose. Chris works with a number of charitable organizations throughout Northern California and is driven by his passion to help families across the state of California build their legacies for generations to come. Thank you so much. Here's Chris and Victoria.
Thank you very much for that introduction, Amanda. So today we're going to jump in and start the discussion with you of how to protect yourself and your children in the event that life does not go according to plan. You never want to think about the day that you will not be there to take care of your children, but it is so vitally important to plan for what would happen in the event you couldn't. We're going to look to answer questions today and with our clients in our meetings, such as, who would you want to be your child's caregiver? Who would manage the money on their behalf until they are old enough? What if they have special needs? What happens once they become an adult? And how will you leave a legacy for them? These conversations are not always easy, but we are here to help guide you in creating a customized plan to protect you and your family. So the first thing we're going to look at is planning for you. When they do the safety demonstration on the airplane, they'll say to put your mask on before helping your child. That is very similar to estate planning. We will protect you, and then we add in the protections for your children. So first of all, what is estate planning? For some of you, you may have never heard this term. Others will have heard it, but not really understand what it means. And then for a group of you, you will have heard it, you know a fair amount, and we're just here to reinforce what you already know. We'll also go over the difference between a will and a trust, how a pour-over will works with your trust, and what your powers of attorney are. So if you have questions as we go, please put them into the chat box. Hopefully we'll have a chance to answer them today. If we don't, please set up a consultation with us so that we can answer things more in depth in a one-to-one meeting. So first of all, what is estate planning? Essentially, we're looking to put your wishes for yourself and your family into action, onto paper. We want you to be able to retain as much control as possible, regardless of the circumstance. Regardless if you're incapacitated or even after you've passed away. So the first thing is, do you need a will? So if you are someone with no real estate, if you have an estate worth less than $166,250 or you are the parent of a minor child, you would be looking at having a will set up. That $166,000 mark is so important because if you have more than that and you only have a will, your estate would still be subject to probate after you pass away. But what is probate? Probate is a legal process that follows state rules. If you've ever worked with a government agency or the court, you unfortunately know they're not known for efficiency. So it can really cause a lengthy delay when you're trying to settle someone's estate. And this is the last time when you're already going through something emotional that you want it to be drawn out and to not have full control. With that, the control does stay with the court. It's on their calendar, it's their rules. And that may or may not be in line with what you would have wanted. The other thing is it's a public proceeding. I'm unfortunately currently going through this with part of my grandmother's estate, and everything that we do is open to the public. She was a fairly private person, and I can't imagine that she would have wanted some of the family drama, let's say, to be aired to other people. The other unfortunate reality with probate is it's significantly more expensive than if you have a trust and it goes through a trust administration, which we'll talk a little bit more about in a minute. The good news is we can avoid this. So if you are someone who doesn't need a will, we look at setting up a trust for you. A trust is a contract between the settlor and the trustee. Settlor is just a fancy way of saying the creator of the document, and the trustee is the person who will carry out that settlor's wishes and manage the assets. In the beginning, these are often the same people, but at some point, you may not be able to manage the assets for yourself, whether because of incapacitation or because you've passed away. You would want a trust to avoid that cost and delay of probate that I just mentioned. Another huge advantage is it protects your privacy because it keeps it out of court and keeps it then within the family. If you are someone who has a higher net worth estate, we can also do significantly more advanced tax planning so that you can pay less in taxes and so your children can inherit more of the legacy that you have built. A huge factor that we're going to talk about today is guardianships. And with the documents we set up, we're able to avoid court-supervised guardianships or conservatorships. The guardian is who cares for your child. The conservator, though, is who would care for you in the event you could not. We want you to be able to name this person ahead of time. We'll say it multiple times today, but our goal is that you will have made these decisions ahead of time so that if something happens, or unfortunately when something could happen, it's a smoother transition and your wishes are the ones carried out. We do this by also supporting our trust with a number of other documents. The biggest downside to a trust is that it only controls what it owns. So we talk at length in the signing appointments about how to make sure your trust will own the assets that you have. If, though, you forget to do that or don't have the opportunity to, we also create what's called a pour-over will for you. This is different from the will we talked about because this one accompanies a trust. It's where you would name an executor. So if something had to go through court, you would have already named the person that would handle that for you. It's also where you name the guardians of your children. So again, we want to make sure that in all circumstances, no matter how undesirable they may be, the control remains with you and ultimately with your family. Two of the other documents we make sure that get set up, regardless of if you get a will or the trust, are your powers of attorney. And there's two main types. Your financial power of attorney is one that exists while you're alive, but if you became incapacitated, it ensures that someone could manage the assets on your behalf, regardless of what the title on them is. Again, this is something we go into significant depth, both in our initial consultation and the signing appointment. We want to be very repetitive so that this information that seems very overwhelming up front will become something very understandable and tangible for you. The medical power of attorney is vital to anyone over 18. In 2004, the law changed that if you did not have a written medical directive naming who would make your decision if you were unable to, no one automatically could. That means your spouse, Your parent or your child would not have the ability to talk to the doctors if you did not have this written directive. By putting in place who you would want, it can help take out some of the stress surrounding the medical event that would have happened to the extent you can't communicate anymore. It's also where you can leave very intimate instructions for the person you've named. A lot of times these are decisions that the person you named doesn't want to have to guess at. And this is where you can guide them so that they don't feel like they're doing something you would not have wanted. You've already told them your wishes, and that can take some of the burden away. These documents ensure that you will be protected no matter the physical or mental state that you're in. And again, they work as a package. We don't want to set one document up without the others because we're left vulnerable to other issues. So we make sure that it's a comprehensive package of documents. Now that we have talked about planning for you, I'm going to turn it over to Chris to talk about how to plan for minor children.
Thank you so much, Victoria. So my name is Chris Carroll. As they said earlier, I'm the CEO of the Copenbarger Law Firm, and I'm so excited to be talking about this today. This is an area that I'm extremely passionate about, and it means a lot to me. I have a 3-year-old daughter at home, and making sure that I provided plans in place for her in the event that something were to happen to my wife or myself is just so important. And so once you learn about it, you have a responsibility to act on it. And so from my perspective, that's what I try to do for everybody that I come across that's in a similar position. Today, we're going to go through a couple different things. We're going to start with why we're here and why we're having this conversation in the first place by going over some frequently asked questions and kind of what it is we're going to talk about. From there, we're going to go into providing for minor children. We're going to talk about and how to choose guardians for your children. We're going to talk about special needs planning and how there's some very unique and special circumstances that can affect the way that you plan and what types of plans that we use. And then we're going to go into different legacy planning type of documents like a generation skipping trust, a dynasty trust, and talk a little bit more about legacy. All right. So as far as the frequently asked questions, how do I protect this new little human that I'm now responsible for? You know, when you become a parent, everything just kind of crashes down upon you like a wave. And there's so much responsibility there. And it's not like, you know, new kids come with a manual on what you're supposed to do and not do. And so it's so important to ask questions like this and to be open to learning about new topics. How do I protect them once they're an adult? How do I protect them when I'm gone if I'm not here as a child and as an adult? How do I protect my child with special needs? And how do I plan for their financial future? Again, both if I'm here or not, you know, what things should I be doing as a parent of a young minor child? And lastly, how do I leave a legacy? All of those are so important, and they all come together in a really unique and special way in estate planning, and that's why we're here. So let's go ahead and start with guardianship and planning for minor children. So your will is where you actually name the guardians for your children. So this is who would be the guardian of your child, as well as who would be the guardian for the estate. And there's a difference there, and I'll go into that in just a second. If you have a living trust, however, this would be done in what's called the pour-over will. All right, so again, this is naming who would be responsible in each of those areas. So the guardian of the person or the guardian of your child would be who physically is taking care of and raising your child. The guardian of the estate is who's responsible for the financial aspects and managing how your child is actually taken care of. And those are two very different jobs and two very different responsibilities and personality types. And so it's really important to take that into consideration when you're picking your guardians, because sometimes they're the same person, sometimes they're different people based off of the responsibilities that each of those positions has. As far as who should the guardians be, and this is one of the most important questions that we get day in and day out from young families. And it should be, you know, if there was ever an area in your life to take seriously, to be obsessive over, to really make sure that you think through every possible scenario that could come up, this would be it, right? This is the person or people that are going to be taking care of your child for the rest of their life, forever, at least their childhood, but even beyond adulthood in some cases. So things to take into consideration are things like their personality. Are they kind? Are they trustworthy? Are they compassionate? Are they loving? Right? It's so important to think about the environment that you're placing your child or your children into in the event that you're no longer here. It's important to recognize that although it's sad and it can be kind of scary to think about what if I wasn't here, you aren't trying to replace yourself completely, but you're trying to get as close as you can. You want whoever those new parents are to love and to raise your child as close to how you would want them to be raised and want them to be loved as you can possibly get. This is where it matters, right? Another question, and this goes to the guardian of the estate, is are they financially savvy? Do they understand investing? Are they good at managing money? Are they good at managing budgets? Or do they earn enough money to provide an environment for your child that you would want them to have, right? Do they have kids? This is a huge one. And how old are their kids? How many kids do they have? If you have 3 children and they have 3 children, you're now doubling the number of children in that household to 6. And now it goes from a household of being 5 people to a household of 8. That's a big difference, right? And so how does that affect them? How does that affect the way that your kids are getting attention, are getting care, are getting college funding? All those different things come into play. Are the kids close in age, right? Do you have maybe if their 2 kids are just graduating high school or going to graduate high school and you've got a toddler at home, are you setting those new guardians back 15, 16 years to go through everything all over again? And do they want to go through that? Another thing here is, are they single? Are they married? If it's a couple or a couple, right? And how are they, as far as responsibility is concerned, at picking significant others, right? Do they have a good history? Because if you're picking a single individual, and now your kids are in that environment and they get together with this new special someone later down the road, that's the environment that your child is living in for the rest of their childhood at a minimum. And if they're married, what happens if that marriage doesn't work out? As sad as a prospect as that is, it's so important to recognize that not every marriage works out. And you want to make sure that if your child is put into a home and that marriage doesn't work out, what then? What happens? Do they stay with the husband? Do they stay with the wife? Do they stay with somebody else? Do they go to a new individual? And this is where having backups comes into play, and it's very important. If you ever were looking for a plan B, C, D down the line, this is a pretty important place to do it. And so having the people that you pick, understanding the difference in roles between the financial side and the actual raising of your child side, and then what would happen down the road in having a backup if you needed one, or 2 backups, whatever the case. Another question that's really, really important that you need to take into consideration is, where do they live? Geographically, how close are they to other family on both you and your significant side, other side, or just your side, depending on what your situation is? Are they going to be in an environment where they get to continue to experience family from your side? Right? I would certainly want my daughter to be able to continue to visit her grandparents and great-grandparents. And that's important to me. And so choosing guardians that live in a place that makes that feasible is extremely important, because you're talking about your child's life here and your child's experiences in the way that they're being raised. So those are all extremely important. Next, we're going to talk about providing for minor children in the minor's trust. All right. So again, I know this can get a little bit confusing, but it's important to differentiate here. Guardians of the child, guardians of the estate. All right. Inside the minor's trust, right? This is where you talk about how they would be raised, not who's raising them anymore, but how they're being raised. What provisions are in there that are going to raise them the way in which you would have wanted them to be raised? So it's important to recognize personality types come into this, right? It's also important to say, and it's okay to say, I want my child to be raised this way, right? And having that written down with clear instructions and expectations. For example, religion, discipline, right? How is money used? Is there an allowance? Are they traveling the world, right? All these different things. Do you want your child opportunity to go to college or a trade school? Is there something that you want them to do or accomplish, like have a gap year in between high school and college that's important to you, and giving them the ability to do so? And so inside the minor's trust, this is what manages and protects the assets within your trust. And this is where you provide the instructions for the guardians on how they are to actually live out and implement the things that you would want. Now, it's really important to note here that this can continue even after your child is an adult, right? Again, this can continue after your child reaches an age of majority. This is important because just because your child turns 18 and they're no longer needing a guardian physically, it doesn't mean that care for that child ends. You've got college, you've got first cars, you've got all sorts of things, weddings and buying a first home that you may want to help with. And all of those decisions come into play inside the minor's trust. So how can we help? What value do we provide here? This is something that we have been doing for over 40 years. Our founding partner, Lloyd Kopenbarger, founded this firm because he saw such an environment where young families weren't being taken care of. This demographic in general, they were just being given a basic will or a basic trust that didn't cover all these different questions and opportunities to lay out exactly how their children would be cared for. And he came to the conclusion, you know what, I believe that these families, their legacies matter. Right? And that's what our firm is still built on today. We believe that your legacy matters. And a huge part of that legacy is your children, right? It's those relationships that we have. And so making sure that you have somebody who has experience in these areas guiding you through these decisions, bringing up topics that you might have not even considered or thought were going to be an issue, and planning for those things. And that's the great part about a comprehensive estate plan, is it is planning for those things that you might not think of, right? It's not a one-size-fit-all document, and it shouldn't be, because God didn't create any ordinary people. It's another quote from our founder. It's so true. Everybody's needs and circumstances are different, and we need to plan for those different needs and circumstances. And so the plan should not be identical from person to person, because everybody is not identical. All right, so enough of that. Go ahead and back over to Victoria to talk about planning and how it's different for a child with special needs. There's a lot of important things to consider in there. So, Victoria?
Thank you. So that was a lot of information at one time, but we're going to give you a little bit more. With special needs planning, we're taking a slightly different look. If your child is going to be unable to provide for him or herself, no matter the age, then your plan is going to need to be hands-on and go deeper into more complex issues. I'm sure most of you know there are many different types of special needs, and with each one is going to come a different set of limitations or challenges. And with that, each person with special needs requires a different level of planning based on their ability to be independent and their need for government assistance. One of the biggest differences could be the financial need. A lot of times we talk about with clients, what is fair? And that is a very hard question to answer, because if you have more than one child, you may feel it's fair to just split everything equally, but that is not necessarily the only way to be fair. Our founding partner does like to say that equal treatment of unequal people is not fair. And in our discussions, we are going to help you design a plan that you are comfortable with and that is fair based on your individual family and situation. Fair to you will likely not look the same as fair to someone else, and we want to provide an environment where you feel you can bounce ideas off of us and play with different ways of providing for your children, especially if they have special needs. One of the biggest advantages to a special needs trust is that your child or children could receive their inheritance without losing government benefits. A lot of times these government benefits are essential, and we do not want you to have to choose between leaving this legacy that you've built for your kids or them having really needed care provided from the government. It's also a trust where other family members can help provide for that child. So if you have other family that wants to know how they can contribute, this could be a great way to do that. It can work within your trust or stand alone depending on what you need. But a really important point is that it exists after you pass away. So again, even if you cannot physically be here to care for your child, have some peace of mind knowing that you will continue providing their care long after you are not with them. One other really important thing that we want to talk about, even if it seems a little bit premature, is what happens when that little human becomes an adult and is heading out into the world. There's two primary ways that they can receive their inheritance. It can either go to them outright as an individual, or it can go into a protective trust that lasts for their lifetime. We may be protecting them from themselves. If they're the person who gets $10 and spends $20, you may want to put different limitations on them, but it will also protect that inheritance from outside predators, such as bankruptcy, lawsuits, the IRS, or even creditors. We also will talk to you about the tax advantages that this has for your grandchildren. So again, how do you continue providing for this family long after things have changed? We want to make sure that the protections don't just stop once they become an adult. You don't stop caring for them once they become an adult, and your plan shouldn't stop either. Now, I am going to slip in here. What about that furry family member? So it was mentioned at the beginning that I have 2 kittens, and that is one of them. And to many of us, our animals are more than just a pet or property. They become a member of your family. So how do you protect them? Well, under traditional estate law, this was really hard to do. And it was very hard for you to be able to provide for them once you were gone. But now we are in a great position to be able to provide protections to this furry family member. You can create a pet trust, which is there to provide for their care, even if you're no longer around. Similar to the minor child, you're going to appoint someone to oversee the trust you set up for them and carry out the terms that you have laid out. And it allows you to set aside money to care for that pet. For some animals, they have medical needs, or maybe you really like to spoil them and you'd like whoever takes over to continue doing that. Setting this money aside can take off the financial burden so that the person can enjoy their new furry family member as well. So we've talked a lot about what we do. I'm now going to turn it back to Chris, who's going to explain why we do what we do and why we're so passionate about the way in which we do it.
Thank you. So as I mentioned before, our founding partner, Lloyd Kopenbarger, started this firm on the premise that legacy matters, that our clients' legacies matter. And that's what we've continued to build upon here 40 years later in serving our clients day in and day out. And the staff that we have at Kopenbarger and Kopenbarger all believe that as well. Some of them are pictured here. Some of their kids are pictured here as well. We're all families just like yours, wanting to make sure that we protect not only our family, but also the other things that come into play when we're talking about legacy. And so, legacy is probably one of my favorite topics to talk about, if not the favorite topic to talk about, because I think that it just is so all-encompassing of the things that drive us every single day as individuals, as humans, in the way that we interact with each other and with the world. And so when I'm talking about legacy, we're talking about emotional legacies that we leave, spiritual legacies. It can be your legal through your estate plan and that transition and how all that works. A lot of people just think of the financial when we're talking about legacy, but you can talk about your physical legacy. How do people remember you being, especially in your later years? That's a really key component of planning and making sure that you are able to end your years in a dignified manner and that physical memory of people doesn't change in the end. And then also, and one of the most important ones is relational. All of those different components come together to create a legacy. For me, I like to kind of simplify it a little bit by talking about the 3 R's. So I'm talking about resources, so that can be your financial, your house, your cars, and all that stuff. Your relationships, those are your kids, your grandkids, your friends, just the people that you interact with and day in and day out, your neighbors, your coworkers. And then the last one is your reputation, right? What do people remember about you? What do people think about you? And the way all this stuff comes together in these different ways is the way that you interact with the world is what is going to build your legacy day in and day out. It is not once you sit down with a law firm and you sign those paperwork, boom, I've created a legacy. It's done. I can wash my hands of it. It's not how it works, right? We continue to affect people day in and day out, and that way that we affect them matters. We will go through a couple of them today. We're going to go through how to leave a legacy from a legal standpoint, creating an estate plan and making sure that things go the proper way, how you're taken care of in your later years. We're going to talk about a financial plan. Broadly, we don't do financial planning at the firm. We have lots of great firms around the country and around the state of California even that we work with. And so we let them handle that, but we will touch on it because it's an important part of legacy. And then the last part is more of that emotional legacy, right? Your family history, your records, and there's some really interesting stuff I want you to consider in there. So let's start with the legal legacy, because of course that's why most of us are here today. So how can my estate plan leave a legacy, right? This is where it's really important, like Victoria mentioned earlier, you take care of yourself first. You put that mask on for you first, right? Because your estate plan at the end of the day should make sure it's protecting you. After it protects you, that's when we start talking about protecting the rest of your legacy, which is your children, your grandchildren, your significant other, right? If something happens to you, you got to go to a nursing home or you're no longer here. What about your significant other if you have one? Really important. How are they taken care of and what access to resources do they have? And then also leaving lasting protections for your children and future generations. If that's something that's important to you and you want to provide for that later on, all of that can be done in the legal portion of your legacy through an estate plan. Also, how are your children and grandchildren going to experience the loss of you, right? Or the loss of you and your significant other? Do they have a experience where the planning was done beforehand and now they're able to properly grieve and have that space and have that environment because you took care of those things beforehand? Or are they going to have to deal with a mess where family starts fighting over who gets what because there were no instructions left? So that's really important. You know, one of the things that estate plans do is they provide really clear instructions on what you wanted so that nobody has to try and guess. And that's what that probate court's going to do. They're going to try and guess. All right. Next is, how do I leave my financial legacy? So so many things that come into play here. You've got your income from your job, you've got your retirement accounts, your designated beneficiary accounts, which is basically a fancy way of saying how do the people you want get your accounts after you're gone, right? Do they need to go into the trust, or can you do that directly through your 401k or your IRA? So those are important things to consider. 529 plans. These are college education or just advanced education accounts for your children. And so setting one of those up, whether you're here or not, these are important things to take into consideration. Another really important one, and it's got a bad rap sometimes, but life insurance. Now, although I'm insurance licensed, I don't do insurance anymore, but I still think that it's important to mention, because when you're talking about the legacy you leave behind, you're talking about more than just your monthly bills, like the mortgage that needs to be paid, even if you're not there bringing in that income. You're talking about future cars. You're talking about college education, beyond the 529. You're talking about paying off debt that you might have accumulated with your significant other up to the point of your departure, right? And so in my instance, I own 2 different businesses outside of my normal job. And within those businesses, there's accounts payable and liabilities and stuff like that. I would not want my significant other to be left with having to deal with those things without the financial resources to provide for those in the event that I'm no longer here. And so it's really important to look at those different financial aspects and really plan for those things. The last one is extremely important, and probably one of the things that people talk about the least amount, which I think is really sad. And this is that emotional legacy. All right. This is talking about family history, your lessons, the things that you learned, though, that one piece of advice that your great grandpa told you when you were little that you carry with you to today, right? Making sure that those things get passed down, because that's what built you and your children where you are now. And so handing those things down in a way that you can do so without being here is really important. Records, this can go for your tax records all the way to when great grandpa sailed over and became an American citizen, or came from this place or came from that place. Really, really important, because that history, again, is what built us up to where we are today. The last one is mementos. And this is where it gets a little bit emotional for me, I'll be honest, this is where you talk about letters and pictures and videos. As individuals, as parents, as spouses, as friends, we've all accumulated memories and experiences of our life up to this point, and up to the point that you're no longer here. How do you want those things transitioned if you're not here anymore, right? Does your significant other or your friend or your family have access to your photos account on iCloud, right? Do they have access to your hard drive where you store all your videos from all your most important memories and events? We all walk around with little digital cameras now where we can record these different experiences, and we don't want those things to be completely lost if something happens to you. It's great having a password on your phone for security and a password on your email for security and all those things. But if everything is lost in the event of you not being here, we want to make sure that stuff can get transferred over. So those digital assets are extremely important. Another one that I think is one of the best things that I've ever heard is leaving a letter, leaving instructions to the people who are here after you're gone, right? For my wife and I, having an instruction manual, if you will, right? Where's the gas turnoff valve? She actually knows where that is, and she told me. But if she didn't know and I did, making sure that that's important information to relay, right? Who does our taxes or when, if that's not something you and your significant other work on together, all the way to how to access the different financial accounts and the passwords and all those things, and then leaving a letter to your significant other, to your family members, to your friends, to your children or future children for important moments in their life. Really big milestones. Like if I'm not here when my daughter graduates high school, what would I want to tell her on her high school graduation day? What would I want to tell her on her wedding day? In writing that letter, and it's hard. It's emotional, it's hard, you don't want to think about it, but these are the things that they would be so thrilled, that would be life-changing for them to still have and be able to hold on to if you're no longer here to do that or not able to do it in person. So all those things into consideration pull into your legacy. I think it's really important that more people start thinking about how that affects them moving forward. I'm going to go ahead and kick it back over here to Victoria to talk a little bit about our process and the costs, and then we'll go ahead and wrap up and get you guys back to your day.
So on that semi-emotional note, we'll talk about the process. We have thrown a lot of information at you, so what do you do with it? Well, first of all, you attend an educational event, which you've already done that, so great job, you're off to a good start. After that, you'll set up an appointment with one of our attorneys. You have this initial consultation where we're going to discuss your needs and the options available. We go in depth so that we can start designing as close to a perfect plan as we can get. After you decide that you're moving forward with us, we go into the drafting phase, which takes an average of 4 to 6 weeks. It could be a little longer in some circumstances where there's an emergency. We can be flexible about shortening this. So if you're in an emergent situation, please don't hesitate to bring that up. After we've drafted it, we do the signing appointment, where we will walk through what these documents say, confirm that it outlines what your wishes are. Then after that, we send it home with you. We want you to review these documents in as much depth as you can manage. We want to make sure, again, that we have put on paper what you want to be carried out. Ultimately, we want this to be a lasting relationship. We don't think of it as, great, you came in, you paid us, see you never. We want you to come in as often as you feel you need. We do educational events all year long. When COVID hit, we switched to online almost instantaneously. We got these webinars going as quickly as we could because we did not want to lose that connection and the education opportunities that we have with clients. So please don't think that if you come in, we're ever going to not talk to you. In fact, we may bug you too often. We send emails, we do postcards, we have these educational events. If you want us in contact with you, we will be there. One of the biggest questions is, what will this cost? I unfortunately can't give a great answer right now because it does depend. If you think about it like buying a car, you can start with the base model that can be perfectly appropriate for certain people. But we then look at what other protections do you need, but then also what additional protections do you want? With us, we go very deeply into both of those topics. Chris mentioned it a little bit earlier, but you can find cheaper trusts online. With those, though, you're going to have some big issues potentially. Often you never actually talk to an attorney. A lot of times you do not get the one-on-one attention. And again, it may not even be an attorney that is working with you or on the documents. The other piece is, a lot of times with these form trusts, you don't find out that they had holes in them until you actually need it. I won't sugarcoat that our plans are more expensive up front. However, I can guarantee that the protections we offer are significantly more expansive and offer greater protections, making your life easier in the long run. The reality is you often don't know the cost of an estate plan until you actually need it. And when you need it is not the time to find out that you didn't have full protection. Our goal is to make the trust process more complex up front so that in the midst of an emergency or an emotional period, things can be much simpler for you and smoother. I guarantee you will know the cost by the end of the meeting. We don't try to hide that from you, but we want to ensure that everything you need is there. So we did talk about a lot. I'm going to have Amanda come back on in just a second to give you some final notes, but we talked a lot about protecting you and your children and how to plan for your legacy. And we hope that through all of this, you will choose us to be the people that you put your trust in. Thank you so much.
So thank you again. We would like to thank all of you for attending our presentation today and truly hope that you receive valuable information that will help you plan ahead for you, your young growing family. Remember, you and your children are important to us and your legacy does matter, especially to those who love and cherish you. If you need assistance with any of this planning, we are offering a complimentary consultation for all of those who have watched this webinar. If you'd like to meet with one of our skilled attorneys, such as Victoria, please click the link in the chat box and we will reach out to you to schedule your consultation. Remember that if we didn't answer your questions today in our presentation, we will most certainly answer it in our appointment. Lastly, we want you to know that they are all here through stages of your life to help you out, whether it's setting up an estate plan for a new family, to protect your newly blended family, or to help administer for someone who you've lost. Our founder, Lloyd Koppenberger, has had a phrase he's used over the years, and that's, if your attorney isn't there when you need them, then you don't need them. We truly take that to heart, and we will be here when you need us. Have a great rest of your day. Thank you for joining us, and have a happy Thanksgiving.